Hello, I'm Brian Opeskin, and I was a Commissioner and then Deputy President of the Australian Law Reform Commission for 6 years, from 2000 until 2006. I would like, first and foremost, to offer my congratulations to the Commission on the occasion of its 40th anniversary. Since its establishment, the Commission has had a profound impact on law reform in Australia and has often led other jurisdictions by example in its processes, outputs and influence. I was fortunate to work on 5 public inquiries during my tenure. They varied widely in subject matter, from technical legal references on federal judicial power to broad issues of public policy. This quality of generalisation is one of the great strengths of the Commission. One of the most challenging inquiries in this period was on protection of human genetic information, particularly with respect to issues of privacy and discrimination. When the inquiry started in 2001, the human genome had not yet been fully sequenced, and some of the concerns about the misuse of genetic information seemed like science fiction. But it soon became clear that genetic information had enormous potential for use and abuse across a broad spectrum of human activity. The inquiry required the Commission to engage with medical researchers, health service providers, insurers, employers, law enforcement, immigration authorities, and even sporting organisations. The inquiry ultimately led to 144 recommendations in a report that was the most comprehensive consideration of the ethical, legal and social implications of the new genetics ever undertaken. Another inquiry that I particularly enjoyed leading was the inquiry into the sentencing of federal offenders, which ran from 2004 until 2006. It was a project that raised a classic federal problem. The Commonwealth can and does enact criminal laws, but offenders are tried and sentenced in state courts and incarcerated in state facilities. How then can fair outcomes be reached so that a federal offender, speaking colloquially, does the same time for the same crime? It was an occasion for a broad review of federal sentencing law and resulted in some practical recommendations that were quickly adopted. The ALRC continues to go from strength to strength, as a quick examination of its completed reports shows. But we shouldn't be complacent in thinking that its future will necessarily look like its past. One challenge for the future is to ensure government funding at levels sufficient to ensure that work of the highest quality continues. Another challenge is to resist the temptation for quick and easy solutions to problems that are very complex. One of the great strengths of the Commission's work has been its extensive consultation with stakeholders, and consequently its ability to flush out problems of potential reform proposals. Rome wasn't built in a day, nor can law reform proposals. The third challenge is to remain relevant to government processes of policy development through an appropriate choice of subject matter. Some inquiries are in fact better undertaken wholly within government departments, but the ones entrusted to the Commission need to be selected judiciously. And finally, there is the challenge of independence. In 1975, the ALRC was established as an independent statutory agency. This has been vital for its high standing in the community and for the continuing willingness of stakeholders to speak with utmost frankness on controversial issues to a trusted institution. That independence must be protected. Once again, I offer my warmest congratulations to the Commission on this special occasion and wish it and its staff a happy 40th birthday.